Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Koehler, and I invite you to my next FCPA Institute in Nashville on May 4th through the 5th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Koehler, and in this episode I am pleased to be joined by Jay Darden, a partner at Paul Hastings who has extensive FCPA practice experience. Previously, Mr. Darden served in the Justice Department as Assistant Chief of the Criminal Division's Fraud Section, where he personally investigated and prosecuted FCPA violations. Thanks for joining us today, Jay.
Mike, thanks for having me.
Now, you were previously a DOJ FCPA enforcement attorney, and there's lots of FCPA practitioners in private practice or other FCPA professionals, whether serving in-house or serving in other capacities, that may not necessarily have the perspective you have as a person who used to be at the DOJ prosecuting FCPA violations. What are some of the individuals active in the FCPA space who may not have prior DOJ experience? What are some of the issues that these individuals need to know about DOJ FCPA enforcement?
Mike, I think the most important thing for people who may not have gone through an investigation and may not have any sort of personal familiarity with how the department conducts FCPA cases is to know that the prosecutors at the department, in my opinion, although they don't always get it right, I think they do always try to get it right. It's very easy when you are an individual defendant who is facing a government investigation, or when you are a company facing a government investigation and having to spend lots of money. It's very easy to cynically believe that the DOJ prosecutors, or for that matter, the SEC trial attorneys, are somehow ill-motivated, that they are looking at you individually or looking at your company because of some sort of personal animus, because the prosecutor wants to make a name for himself and then leave, because you have a misperception that the particular fraud section office at the department gets a cut of the fine and therefore is trying to jack it up. It's really easy when you're under the pressure of a government investigation to want to attribute bad motives to the people who are on the other side. And my experience is just the opposite of that. I think that the government lawyers, be they from the department or be they at the SEC, do try to get it right. As I mentioned a bit ago, I don't believe they always do get it right. Certainly you can have debates and differences and reach different conclusions. In fact, the way I got into white-collar practice in the first place many years ago was after representing an individual defendant who was acquitted at trial that wasn't an FCPA case. It was an accounting fraud case. But it's evidence of the fact that the government can, in fact, be wrong. But I don't think they are intentionally wrong or try to be wrong. It's just the defense lawyer's job to show them when, in fact, they are wrong.
The flip side of that question, I guess, is DOJ FCPA enforcement attorneys who may not have experience representing corporate clients, whether as outside counsel or as inside counsel. What are the top issues that you think DOJ FCPA enforcement attorneys who may not have had that real-world practical experience with business clients, what do you think they need to understand about an FCPA private practice career, whether as an outside lawyer like yourself or in-house?
Mike, based on my own experience, there are really two or three things that I think are important there. One is that specifically with respect to the FCPA, and in particular with respect to companies under FCPA investigation that are not based here in the United States, I think sometimes DOJ can get unnecessarily frustrated with the pace at which decisions are made by overseas companies. Oftentimes, that slow pace, or what DOJ perceives as that slow pace, can cause DOJ to believe that the company is being intentionally obstructive, when my own experience shows that's exactly the opposite case. The fact of the matter is that as a result of the FCPA's extraterritorial reach, DOJ investigates cases in companies that are all over the world. And depending on which country a company is based in, their system, from a legal standpoint, from an investigative standpoint, can be totally different than the U.S. system. The way defense lawyers and prosecutors interact in the U.S. is foreign. The pace at which things move in the U.S. sometimes can be quite different from what they are used to. And even if in a foreign company you have a general counsel's office or a compliance office that has some familiarity with how things work in the U.S., oftentimes the more senior level executives, and in particular the board of directors, will have no familiarity at all. And I think it's easy for DOJ to get frustrated because they feel like they're not speaking the same language, so to speak, as the foreign company. But in fact, they're not speaking the same language. And you need time to bring companies along and bring DOJ along in those types of situations. And I think that sometimes DOJ lacks an appreciation of that fact.
Yeah, I mean, the slow pace is often talked about in the FCPA space, and normally, at least from my perspective, oftentimes it's the frustration companies have as to the slow pace of the DOJ and the SEC, recognizing that because of waiver of statute of limitations or tolling of statute of limitations, there's very little real-world practical time constraints on how the DOJ goes about its job, and we are very frequently seeing FCPA investigations drag on for 3 to 4 years and sometimes even longer. Any other issues now that you're in private practice that you think DOJ FCPA prosecutors perhaps need to better understand or be more sensitive to?
There's one other that I think prosecutors can be more sensitive to, and frankly, I think this is true both in the FCPA space and in the white-collar investigation space more generally. And that is, there are certain requests that prosecutors routinely make, or certain offhand comments that prosecutors will make during a meeting that to them are very normal, everyday ways of talking. Sometimes the vocabulary is the vocabulary of, as you would expect, a criminal prosecutor, and terms like target, fraud, terms like spoliation of evidence, things like that can get thrown around in a very casual way. But when you're a defense lawyer and have to go back to your client and report on who said what at the meeting, you want to be accurate with your client and tell them what the prosecutor said. But sometimes I think the prosecutors don't realize how significant what they may perceive to be a minor comment, how significant that can be taken inside the walls of a company. And I do think sometimes DOJ and prosecutors lose sight of that, and it's one of the things that I often struggle with my clients, is sometimes to have to explain, yes, this is what the DOJ prosecutor said, but they really don't mean it as badly as it sounds, and that can be frustrating.
Do you think the dynamic you're just explaining also applies to the scope of FCPA investigations? For instance, recently DOJ officials have said that they don't expect companies to, quote, boil the ocean. And,
Right.
you know, a lot of FCPA inquiries obviously begin with conduct in one particular country, and then the next thing a company knows, it's doing close to a worldwide review of its operations. And, you know, I was in private practice myself, and I know that sometimes around the negotiating table, a DOJ or SEC enforcement attorney can, you know, sort of make, as you're describing, a casual remark of, oh, have you looked in countries X, Y, and Z? And then the next thing, you know, the company has a team of lawyers and forensic accountants in countries X, Y, and Z, when perhaps the DOJ or SEC attorney were not as strident in their vocabulary, perhaps as they intended to be.
I think it's a great point, and I agree with it 100%, Mike. I do think that there are times when the scope of what are already large FCPA investigations get unnecessarily expanded. I do think oftentimes that happens probably for less conspiratorial reasons than some might suggest, but it does happen, and I think it's really important. Going back to our conversation earlier in the podcast, I think it's really important for defense lawyers to use their judgment and to press DOJ on comments like that and make sure that DOJ understands what the implications are of making a request like that for another country or, depending on the nature of the company, an entirely separate business line. And just one more comment on that point, I also think that very much relates to what we were talking about previously on timing. The point I was trying to make was really, timing of a particular decision within a company. The point you were making was the timing of overall FCPA investigations writ large. And I do think those can go on too long. I think they often do. And I think, frankly, the slow pace of some of those investigations can exacerbate the risk of the investigation getting expanded to other countries that results in a, to use your phrase, sort of boil the ocean kind of investigation, when in fact that may not actually be necessary, either for the company or to respond appropriately to the government's inquiry. So I think that's a great point.
And indeed, part of the calculus in deciding whether to voluntarily disclose or not, which is something the DOJ and SEC clearly want companies to do.
No question about it. Now, I do think that a company may in fact choose to look at their business in other countries or expand their own inquiries beyond what DOJ may be looking at. But that, in my mind, is a totally separate discussion from what gets disclosed to DOJ in the first place. A company has to decide how it wants to conduct its business. It has to decide what it wants to look at. But just because you're reviewing something internally does not automatically mean that you're going to self-disclose whatever it is you find to the government. That's an inquiry that needs to be taken one step at a time.
So you've been on both sides of the FCPA, so to speak, both in your current position representing business clients in this space, and then at the DOJ investigating and prosecuting FCPA violations. 2017 is a notable year of sorts in that in December the FCPA will turn 40. And my next question is, if you could change anything specific about the FCPA, either the statute itself or how the FCPA is enforced pursuant to DOJ and SEC policy, what specific changes might you suggest to the FCPA landscape? And for each change, why do you believe that change is necessary? And do you think that whatever change you're going to tell our audience about next will actually be made?
Sure. I have two thoughts there. The first, we've actually spent a fair amount of time already talking about, so I won't go over it in much detail, but that is the timing of the cases. They take too long, and they're too expensive. And ironically enough, from DOJ's standpoint, I think the length of corporate investigations actually can complicate what DOJ says is its goal of actually prosecuting more individuals. And so if I could change one thing, I would change the pace of the investigations and how long that process takes. For what it's worth, I do think there has been some improvement on that issue in the last few years, and I'm hoping that it will continue to improve.
But if I may, on that point specifically,
Sure.
though, how do we actually accomplish that laudable policy goal? Is it companies refusing to waive statute of limitation defenses? Is it companies refusing tolling agreements? How do we actually accomplish this?
It's a fair question, and to be honest, I'm not sure that I know. I don't think that a blanket statement of refusing to enter into tolling agreements or cooperating less with respect to the production of overseas material that's beyond DOJ's reach, we could come up with a whole list of things like that. I'm not sure that any one of those things is going to be the solution because, at least in my own experience, a company's decision to agree to those requests or to provide that material or to answer DOJ's questions is very much a context-specific decision within that company and within the investigation that's ongoing of that company. So I don't think there's a silver bullet there, but I do think both DOJ and outside counsel have to have a mindset that we're going to try to move things along. And maybe, again, going back to our prior discussion, maybe that means having more rifle shot types of investigations where you're looking into a particular scheme in a particular country rather than, and prosecuting that if there's wrongdoing found, rather than perceiving that your role is to investigate the entire company and how they do business everywhere. Because even small companies, if their entire business practice are being looked at, that's going to take a long time. It's going to be very expensive. And so I think a change of mentality is necessary. But exactly, Mike, how that's accomplished, I'm not so sure.
What about some of the other changes you might make, either to the actual statute itself or perhaps how the FCPA is enforced by the DOJ or SEC?
one other thought on that, and again, I'm going to confess to not quite knowing how to implement my own idea, but it is an increase in the number of, at least under our current construct, the number of declinations from DOJ. I think that when you're talking about a non-issuer company that's under investigation, you're really talking about, from an FCPA standpoint, criminal liability or nothing. And my own view is that the criminal law, and in this case, the criminal law of the FCPA, is a pretty blunt instrument to try to encourage companies to have better business practice, to improve their compliance programs, and to respond when wrongdoing in the form of a potential FCPA violation is found. I would like to see, just like you have for issuer companies when the SEC is involved, some sort of alternate way for non-issuer companies to be investigated such that every decision that they are making isn't one where they think, okay, well, if we don't do this or if we don't agree to this, we as a company could be prosecuted criminally. As I said, that's a blunt instrument that isn't always the appropriate way, in my view, to improve practice in a particular company or improve practice in the market.
I mean, that of course begs the question, what is the definition of a declination? I think a lot of people in the FCPA space, myself included perhaps, have vastly different interpretations of what a declination is. In my mind, at least, a declination is an instance in which the DOJ believes, based upon the facts, based upon the law, that if put to their burden of proof, they have a provable case. Others will say on the complete opposite ends of the spectrum, if the DOJ opened up an investigation and if there's no enforcement action, that's a declination.
Right.
What is Jay Darden's definition of a declination?
Yeah, and Jay Darden's definition, at least for purposes of the discussion we're having here, is really trying to stick a square peg in a round hole. I'm using that term as a disposition that is doesn't involve criminal liability, as sort of looking for a way for, as I was mentioning earlier, looking for a way for companies not to feel like the only option is prosecution or complete exoneration and getting off scot-free, because certainly companies that undergo lengthy, very expensive investigations don't feel like they get off scot-free, even if they get, under today's standards, a declination at the end of the day.
Well,
so it's a complicated question. I don't know what the answer to my own problem that I've identified is, but I think that non-issuer companies are at a disadvantage because they don't have, like you have with the SEC, an intermediate way to be investigated and resolve cases, and I think that's something that's missing from our enforcement rubric that we have.
I don't often play the role of DOJ, but let me hear for a second. Isn't that what the so-called declinations with disgorgements were about? There were two of those last fall. One against, these were both non-issuer companies. The first company was HMT, and the second company escapes my recollection at the moment. But these were declinations with disgorgement. Now, in my mind, I think this elevates form over substance. These were FCPA enforcement actions, no matter what you call it. But do you think that was the DOJ's attempt to perhaps find some middle ground?
Honestly, no. I think that's probably more about DOJ's policy of now always requiring disgorgement in their cases, whether that's through the SEC process if you're an issuer or through some other process if you're not an issuer. The reason I say no to that question, Mike, is that the companies who are on the other side of those investigations are still being investigated by criminal authorities. And at the end of the day, even if they get a declination, they're negotiating the declination with criminal authorities, knowing that the alternative is criminal prosecution. And so I think that dynamic of not having the middle ground that I'm talking about here still exists even in the wake of those more creative settlements. And I applaud them. I think they're good. But I don't think they're the answer to the problem I'm talking about here.
And, it's interesting. The FCPA does contain, in the statute itself, the ability for the DOJ to bring civil injunctive actions. And I think the last time that happened was, in 1999 in the Metcalf and Eddy case. But the DOJ does have, as a matter of statute, civil injunctive authority in the FCPA context. And perhaps that's the answer. I don't know.
It may be the answer, and I will defer to you and your knowledge on when the last time they exercised it. I certainly don't remember them doing it while I was at the fraud section, and I haven't had any experience with them doing it since I've been out. If that is the remedy, or if it could be the remedy, the one benefit we have there is it's something that's already in place. But again, I think there has to be a change of mentality there, and the fact that you have to go back to 1999 to find a recent example shows that middle ground solution is not really what's on the minds of the department when they're thinking about ways to resolve cases.
Yeah. The final question I have, and this is, what I think is probably the one of the more notable developments in 2016, and that's the internship and hiring practice cases. We've had 3 of those now, and certainly from a matter of public reporting, looks like there's several additional cases in the pipeline. Now, as to one of these enforcement actions, you said, quote, it's not the U.S. government's job to regulate hiring policy. Can you elaborate on that point?
Yes. I think I said that, if my memory serves, in connection with the BNY Mellon case from a year and a half ago. And I still think that's the case. I think that because some of the so-called internship, or sometimes these are referred to as princeling cases, because the cases are a little sensational with who it is who's getting the internships, it's the focus on the job that has been the focus of the public reporting. And the suggestion that because someone who got a job at one of the banks or a sovereign wealth fund or some other company, somehow that automatically implicates the FCPA in the event that person got a job through alternate means. What I was trying to identify with that quote, and still believe, is that that's not a sufficient basis for the government to be looking at these companies. Companies can hire whom they want to hire in the methods that they want to hire them. What's important from an FCPA enforcement standpoint is not the person getting the internship, or even if the internship is given to somebody outside the company's normal practice. The question is whether the conduct of the company in providing that outside the normal practice, combined with all the other facts and circumstances in the case, actually indicates an intent on the part of the company to provide some benefit to the foreign official. And I think the purpose of the FCPA and the statute's jurisdictional hook linking back to the foreign official has gotten lost in a lot of the reporting on those cases and in a lot of public analysis about those cases. And I think that it's really important that we stay focused on what it is the FCPA actually prohibits and whether or not this implicates that, rather than just getting exercised and putting a company through the ringer of an investigation just because they've hired somebody famous or somebody linked down the line to a public official.
No, it's a good point, and to state the obvious, I think the general point you made there, could apply to a lot of FCPA settlements, where it is on some level an open question as to whether the statute has been violated and whether the enforcement agencies could have prevailed when put to their burden of proof. We've had 3 of these enforcement actions already. None of them have been subjected to any meaningful judicial scrutiny, nor will the next ones in the pipeline really be subjected to any judicial scrutiny. But I think they will grow in number.
No, I think that's right. And just one final comment on your observation there. I think there's a similar, not tendency, but similar potential for the particulars of the statute to be overlooked in the areas of political donations being made overseas. As we all know, the FCPA is written so as to include in the definition of a benefit a foreign political donation. But anyone familiar with U.S. politics and familiar with U.S. prosecutions for political corruption here understands that there are political contributions that are perfectly legal. There are political contributions that go right up to the line, and there are political contributions that are intended as bribes. When I came out of DOJ, I restarted my private practice at the old Patent Boggs law firm in Washington, D.C., which made a name for itself in lobbying. All of that conduct was perfectly legal and appropriate, and it's why it was such a well-regarded firm that I wanted to go to. On the other hand, you had the Jack Abramoff scandal, which is lobbying and political donations of an entirely different nature. Well, those same types of subtle distinctions exist overseas as well. And I think it's really important when you have a case in an overseas country that involves political donations, not to lose sight of the fact that as a defense lawyer, you need to look into those issues and make the same distinctions on behalf of those donations in that country as you would be doing if the issue were a political donation here in the U.S. Otherwise, as you pointed out earlier, you're glossing over the very requirements of the statute and what makes that kind of payment illegal in the first place.
No doubt, I think there's a fair number of double standards, including the ones you just mentioned, when it comes to FCPA enforcement and enforcement of other U.S. laws, including the domestic bribery statute, and no doubt that could be a subject for another complete podcast. But I do appreciate you taking time to inform our listeners here and to share with them your perspectives from the DOJ and now in private practice and for the how the FCPA and FCPA enforcement can be improved.